We're going to start here with Mike. I'm going to just chat with him a little bit about his experience, and then we'll have a panel discussion with some of the lawyers in the audience about what this case means for data security and how the Federal Trade Commission governs privacy and uses its unfairness authority more generally. So let me just get started here by introducing Mike Daugherty, president and founder of LabMD. We're going to talk today about his new book called Devil Inside the Beltway, which comes out on
24th
September 24th. So Mike, let's just get right into it. First of all, so who are you and what is LabMD?
LabMD is a pathology laboratory in Atlanta. We test for prostate cancer and bladder cancer. Basically every specimen that comes out of a urologist's office gets sent to us in Atlanta from various urologists around the country. And we specialize in having our pathologists really have a very high degree of expertise in diagnosing those cancers. So we're a niche player and a boutique, small private company.
How many employees do you have?
25.
Okay, so you spent the last 4 or 5 years building your business, finding new...
Since 1996 we started.
And you've been focused for the last 4 or 5 years on building your business and better serving doctors and patients, right?
Correct.
Or have you been distracted by other things?
What
have you been doing for the last 5 years?
It's been going on since 1996. What are you talking about? Yeah, we've been building away until 2008, when we were contacted by what they call themselves I believe it's a security intelligence firm called Tyversa, that they had found one of our files on a peer-to-peer network. And that was, I can't tell you, that day was really a big deal. It was an electric shock, and everyone was freaking out, like, you can't say anything more to people scarier than your patient data's out. So we jumped on that football trying to figure out, what is this? What's going on? So this is a stranger in the night, out of nowhere as far as we were concerned, saying they have this intimate information. And so we immediately, patients first. So first thing is, where is it? Hack it down. I mean, bad word. Shut it down. Then remediate outside, make sure it's nowhere out, and then sort of debrief.
Okay. So the file, so you get a call from this company,
Tyversa.
And they say they have a file that they've found, and
Correct.
they offer to help you fix it,
right.
Fix the problem if you pay them.
Well, and that was because our first questions were, other than, okay, prove you have it, and then we got it securely, and that was that, they did that, and then how'd you get it, what's the IP address, what are the circumstances around it, and I immediately was suspect, so this is all in writing. And no answers would come back unless we signed a services agreement. And then eventually we asked for a services agreement to see what this was about. And at the same time, we're talking to our lawyers and getting advice on how to handle the actual issue. And they wanted $475 an hour and at least 2 weeks' time to work on it. And it was all about, could it be out there? So we went looking.
So before we go on, so what is the file? What's in it?
Oh, so we opened the file, and the file was a billing file. All the balances that our patients owed the company post-insurance payment. So it was not in the medical floor. It was in the financial office, and it was basically every code we needed to file insurance and what they owed us. So it was 1,700 pages in a PDF with over 9,000 their balances were, and it had their no addresses, social security number, diagnosis codes, policy number, group number.
Okay, so you said that you responded quickly. What did you do? How did you conclude that Tyversa found this file?
Well, they're the ones that told us, and meaning the circumstances around it. I mean, we immediately went looking. I mean, we knew immediately by the file where it would be. There's only one place that would generate that file. So that was immediately the billing manager's workstation, and we just marched right up there, and there was a program called LimeWire on her workstation, which was against company policy. To this day, we don't recall seeing it on our desktop even. I think we found it by digging into the software. I didn't actually do it, my IT guys did. She was quite startled, had been using it, was aware it was against company policy, just thought she was sharing music. We were, at that point, we're in the dark and panic-stricken and patients are first, so it's kind of like, get rid of it. So we deleted the file, and we eventually isolated that workstation, I guess it was the word. Go ahead.
So, okay, so there's LimeWire on this computer, even though that it wasn't supposed to be. before we go on, what were you doing at that point to make sure that your employees didn't install LimeWire?
Well, we had, I mean, again, this is 2008, so, and I'm not going to belabor the specifics, but our outside technical people we had firewalls, we had up-to-date servers, we had all the technology that you standard would have.
To protect your
to
servers
protect
from
the
attack.
servers from attack. The insidious thing about P2P software is it transcends all those barriers, and at that time it was an unknown entity. And so the industry, and I'd say the business community, and actually the government too, no one understood the vulnerabilities of P2P. And certainly they understood, this is like, I could say this is son of Napster, and we all know the word Napster, but it was used to listen to music, just like that was. And she was listening to music. So when we explored this, we found that this was one folder that had approximately 900 files in it. About 860 were all of music. There were 40 files in there that had patient information, but all but this one had everything redacted out. And really in that message of, like I say, blurred, like a nude body's blurred on television. So LimeWire does not make your network per se vulnerable. It makes that folder shared vulnerable. So in a small company, a medical laboratory where we had 3 or 4 servers and 30-something workstations, even that one workstation wasn't entirely vulnerable, just that one folder. And it was and that folder had 900 files, and one of those 900. So we're talking bad luck, I guess. Now, then, so we got rid of that, and we looked at...
But before you go on here, so could anybody install, any of your employees install software?
Managers could.
Okay, so you limited the installation to managers. What did you do to enforce your corporate policy at that point against installing things like
We
LimeWire?
had policy books in education,
Okay.
you know, in the IT, and we had walk-arounds by management as well. So you know, in hindsight's always 20/20. We just even don't remember ever seeing it on the desktop.
Did any of you? So you said you had outside security
Outside company
that you'd worked with. Did anyone tell you that you should be doing something in particular to look for LimeWire?
No. I mean, not in a specific sense. We didn't even know what LimeWire was in that sense. I mean, again, hindsight's 20/20. I don't think people even knew what LimeWire was.
Okay.
So
you get this call from Taversa, and you say, we're going to fix the problem ourselves, and you do, and sounds like you tell them to
well,
take a
we didn't
hike.
even tell them that. I mean, we don't even know who these people are. We didn't give them any information. Advice of counsel was, who are these people? And they want to identify themselves if they have it, and that's it. So there was not a lot of communication, especially when you're a medical facility. You don't answer the question just because a stranger asks. So that is not what happened. What happened is we used our in-house people and outside, and we just, in our attorney, on the advice of counsel, we went and made sure that the problem, the hole, as you want to call it, the vulnerability was taken care of, and then we looked outside to find out if it was anywhere else as best we could. And as we were looking for it outside, then we got a call from the file, and any evidence of the file. We got a call from Taversa, an email from Taversa again saying that that's evidence that people are looking for it, and we were like, yeah, that looking for it is us. But that communication was also very disturbing because that gave us a real big brother feel, like who is watching us here? And since we were being communicated with about that they can tell, but they aren't going to tell something like we asked what IP address would it come with. I'll have to check that result in the services agreement. That was the way that communication.
In other
went.
words, pay us before we tell you anything.
Yeah, there was a services agreement. That was a requirement. That was the standard word. We'll need a services agreement.
So what happened next?
So it got a little annoying. We felt we were remediated fine. We had relied on our own people. It was none of his business what was going on, and so we had to tell him to only communicate with our lawyer. And so we didn't hear. That was the summer of 2008, and then in November of 2008, counsel for Taversa contacted my counsel and said that they felt that they had to turn this over to the Federal Trade Commission because it had patient information in it. So at that point, you have to understand, we had a very positive relationship with scientists that work in the government. That's who inspects us. That's who we work with. And we were not a new company. We're small, but we'd really, I thought from my prior experience, fine. I mean, they're going to do their due diligence, and it's not out there, and we get along great with these people. So.
Was it your belief that
Yeah, oh no, they absolutely want us to be a client. Oh, they wanted us to be a client. Absolutely.
And
I mean, that was a client services agreement.
And you said no.
And I said
you fixed
no.
the problem yourself.
Yes.
And then they turned you over to the FTC.
Correct.
Okay, so the FTC gets into the picture.
Then we had a year and a half of silence, basically. We had 14, because nothing happened until January 2010, except that we are, I can't, I don't bang my own drum here, but we really are conscious of all this and shocked because we interface with physicians' offices all over the country. And the irony was we're so far ahead of everyone else that we see. It was just really strange because basically we're a relatively new group compared to the technology that were in physicians' offices. And so it was quiet, and we kept looking and still never saw any evidence of it. And then in 2010, we got a phone call from the Federal Trade Commission saying that they're starting a non-public inquiry. The words are always so important. And we will be getting a letter. So we received 11 pages, single-spaced, asking a lot of broad questions. Now, hindsight's 2020. I still was like, fine. We're transparent. We'll just tell them everything, just like how we work with DHR and our licensing. I mean, we have nothing to hide here. And so we did that. We gave them within about, it took about 7-8 weeks, but we gave them about 5,000 pages. I mean, we're talking maps, write-ups, software evidence, layouts. I mean, just, and their questions were quite broad and unclear. And so and I call the word dump trucked it. We just gave them everything, and actually later invited them to come to Atlanta, which they didn't want to do. So that was the beginning of stage 2, and that's really dealing with the Federal Trade Commission. And those first 6 months of 2010 were, we're always cooperative, and we were always giving them what they asked for. But at that time, I'd say we were also cooperatively naive about who we were talking to and the agenda. And so we only till we flew to DC and felt like I felt like I was on an episode of CSI. I had my lawyer and my VP and I. Did I feel like this is not transparent? They're not telling us what could be wrong. They're not. The questions are repetitive. They were very upset in the very first call that they said we didn't answer their questions, which was, we were just shocked by that. We're like, are you kidding me? We've just given you so much information. How could we have not answered your questions? And so,
and in fact, you gave them more information than they had asked.
Yeah,
for.
I think we just
laid
as much out. Yeah, so I don't know if it wasn't the way they're used to getting it, or if it wasn't just in a perfect box. I don't know, but it was not a flowing back and forth relationship. That's certainly for sure. And so we then decided, we're done relying on any verbal. Verbal is not working here. So we're, regardless of what we have a verbal request, we're going to react to what we get in writings, because we're seeing a misinterpretation, miscommunication going on. So let's just have it in writing so everything's on the same page. That is the risk of then getting broader questions, but at least it's something that you can stand on. So we, at that point, they would come and go. I talk about it as an emergently slow pace. And this now is 2010, and we've had about 3 or 4 submissions. This is costing us a lot of money. We're into 5 figures at this point. And I'm learning about Section 5. And I'm incredulous about Section 5. Because, I deal in the medicine science world where we have like facts and rules and boundaries. And
that's the underlying legal authority the FTC's claiming.
Because I'm like going, wait a minute, we have no evidence this is even out. And we don't have any evidence that there's patient data vulnerability, and no one will answer any questions. And if you want to upset them, ask them what the standards are. What? so my other question was, very naively to my lawyer, how can they do this? I know that now, and then we go into Section 5 education.
And so to be clear, what the FTC was saying to you is they'd said to some 36 other companies at that point was that you had unreasonable data security practices, and that was an unfair trade practice. But they never specified, did they?
Not even that. I mean, it's an assumption. I mean, the words are even broader than that. They just point you to the law, and they don't even say that. They don't accuse you. It's a non-public inquiry. They just ask you questions. You can read Section 5 yourself, and off you go. The most they would do, they wouldn't even give you that much information, Berin. The most they would do is say, here's another consent decree. Look at that. That's how they educate you, is look at this. There is no answering questions about specific or what you might have violated. Absolutely not.
Okay, so how long does that process go on, that being in limbo?
Well, you don't know. They never tell you when they're finished, number one, so it could be in limbo even to this day. But in that specific instance, we did not hear from them until in 2011 after that.
Okay, so they send you this letter in 2010, they start this open-ended inquiry.
Correct.
And then things heat up. They decide that they want to ask more questions, they send you a formal compulsory investigative demand.
Yeah, I mean, I'm sorry, I don't want to jump to it, but I would say, look, that did not come until later. The first stage was information. Look at these decisions. You're going to have, what is a consent decree? The consent decrees were 20 years of biannual audits at our expense. 20 years. To this day, we're still going, what's the standard and what happened? Can someone tell us what the standard is and is it out there? I mean, and so I went to independent experts and I asked them and they're like, no. This is not, this is the wrong way to do this. We wouldn't even call this a breach. So I'm like, I'm more than willing to work and improve and be accountable and compliant, but I need to know what the laws and the boundaries are. You mean you can make them up as you go along? Is that what you're telling me? And so I'm finding lay people and people in medicine and law outside of government law shocked, and I'm finding people inside of government law going, oh yeah. And so that was a problem for me because we're just okay with that because that's the way it is around here. And my problem was a lot of companies signed these consent decrees then, and the consent decrees are like, isn't this just a friendly agreement where you admit no wrongdoing and we put out a press release that fries you? Well, we diagnose cancer, and for a press release to go out in tiny fine print that says there's no admission wrongdoing, but for some reason we admit that we'll submit to 20 years of biannual audits to then open Pandora's box to additional repercussions when we don't have an original answer of what the transgression was someplace I wasn't going to go. Not out of some idealistic, principled, zealot type point of view, but more of like, look, reality is, unlike all these other settlements where they admit they've lost tons of data, we don't even know it's out there and no one will tell us it is, including you. But also, if you put that innuendo out there for cancer detection to our surgeons that have an attention span of 0, so my competition's running around saying, hey, did you see they signed a consent decree and their data security practices could be suspect, but they admit no wrongdoing. Damage done, game over.
Okay, so you're still in the investigation phase, and as you say, the FTC hasn't actually exactly made clear what the legal issue is, but they've made clear that where they're really going is they want you to sign a consent decree in the way that other companies have.
That's way fast. I mean,
we need to be way faster.
Okay, but I'm going to sum it right up, but that's fine.
So
but the end of 2011 is when finally, after almost 2 years, they say, we'd like to talk to you about signing a consent decree. That's how long it took, just to get to that. And so that was the first moment I told them something they seemed to have never heard before. No. That was a real big shock. And so then we went to, then that became the last stage of the game, which is, well, we're going to sue you. And this aggressiveness, this posturing aggressiveness that didn't happen. And when you tell me you're going to sue me in a week and you don't, I don't believe much further of what you're going to say. So I'm going to watch what you're going to do, not what you're going to say. And I think they are much used to bigger companies with lawyers and SEC and fiduciary duty concerns and getting used to roll over than having to actually worry about us believing what they say. So anyway, then they filed, and they have a nice habit of wanting to file everything against you the Friday before holiday weekend. So Merry Christmas 2011, I got a CID asking me to sit for...
Subpoena.
It's a judicial subpoena, a government subpoena on steroids. And basically they want to sit. Now that is not a lawsuit, and this is after we asked them, is there anything else you need? And the answer is no. So would you like to come down here? No. Is there anything else you want to know? No. Now we want a CID. So that was when we decided to take this on and get the bottom of what's going on. And we really, the credibility of the Federal Trade Commission with me and my company completely imploded at that point, so that we wanted to get to the judicial system. And we needed to get out of this, what we considered a kangaroo court. And so we moved for the next year to get out of to go through the administrative process, and so that we could get out of the administrative process. And so we filed a motion to quash, and the people that are bringing it against us have the power to make that decision. That seems objective, doesn't it? And then we went to the full commission.
In other words, the commission itself really is the judge of whether the
Right.
subpoena
So the jury is the judge, and the judge is the jury, which the last time I checked the Constitution is not the way we structure the branches of the government, but here we are. And so we went through that, and we thought, okay, we have to get through this, because the fact of the matter is the judicial system's not going to pay attention to this unless we've exhausted the administrative process. So maybe we'll get lucky and the administrative process will work in our favor, and that would be great, but the odds are huge that's not going to happen due to such words as wide deference and all that. So we knew that the odds are really slim, but we had to get through it. And so we got a lucky break when we objected to Julie Brill's decision and asked for a full commission hearing. We got a vote of 3-1-1. We had Olhausen abstained, but Commissioner Roche dissented, and he had a very nicely written dissent about the facts underlying the case.
Questioning whether it's appropriate for Taversa, which tried to extort you, to have brought this case to the commission.
Yes, and I have to be somewhat careful with the word extortion that you said, not me, but yes.
Well, that's essentially what his dissent.
And you say that, not me.
Okay. So let's just make sure we frame the panel discussion here.
Right.
So if you go through this, you finally get your day in court about the administrative subpoena.
Right.
And the federal judge says, well, as a general matter, agencies have very, very wide deference about administrative subpoenas. The judge says, I find this very troubling. I question whether there's really a case here if it actually proceeds, but I have to let the administrative subpoena go forward.
And that was 11 months later.
So let's fast forward. Okay, so finally, what happens in August?
So in August, so now we're talking, so now August of this year, they file a complaint.
It's 3.5 years.
Yeah, and they file a complaint.
The FTC sued you finally.
Right, in administrative court, not federal court. And they filed a complaint, and it has, it's at least we'll try to get someplace. But being that we're administrative court, we'll see. I think we're at the end of the beginning. We're not at the beginning of the end.
Okay, so let me just ask you a few quick questions before we bring the panel up here. So there have been 48 of these enforcement actions thus far. Mm-hmm. Every single company has settled, except for one, besides yours. Wyndham Hotels also has challenged the FTC. So that lawsuit's currently pending. But you decided you were going to stand up to this even before Wyndham decided to say no. So what makes you different? Why did you not roll over?
Well, first of all, I don't know. I can't speak for why the other firms rolled over because I never know about them until after they settle. I did speak to one of them that's very recent that doesn't want to be named, but I think it's resources. I think it's the impact on the organization. I think it's a situational thing. I think I'm not.
Well, hold on. So you're a small company. Even big companies have.
But ours is a life or death situation. Theirs probably isn't, because small or big, when you do reputation assassination with the innuendo that we have this when there are no standards, it's something that we couldn't accept. I mean, we have two lousy choices, and the process was and is appalling. And so it really was. I don't have a choice. I mean, there's no there there.
Okay. so just two more questions. So what else makes your case different? All those other cases.
The fact that I believe they had breaches and they had data out, and we still have no proof that there was a breach or data's out. We know someone came in and took it, and we found out that Homeland Security had funded $24 million towards a study with Dartmouth and Taversa, and that was part of that study. So that's a whole different animal than those other situations. So we don't feel like, nor do we want to be bulked into, we're the same as them, but we are standing up and they didn't. We don't feel like we're the same situation as the other ones.
Your facts are different.
Correct.
So is it fair to say in the end that there's this line of cases where companies failed to secure data, there was a breach, the FTC sued them, they settled. In your case, the ultimate issue at stake was not that you didn't have good data security, you didn't set the passwords well on your routers or leave them as defaults, but rather it was this particular program, this LimeWire software, that was designed in a way that really tricked users into sharing more information than they realized.
Subsequently, we discovered that on our own because they wouldn't tell us anything.
So just one more question. What do you think's at stake here? What is this just about LabMD?
No,
or is there
I
a
think
bigger
this just,
story?
I'm caught in the crosshairs, and I say the ball keeps getting hit across the net harder each direction, because now I'm in this perfect storm of this data security, and it's a fundamental issue. It's not case specific. It's about due process, the power that they have, the ask forgiveness later administrative state type government agency mentality that seems to permeate, the fact that we don't need to have standards in a technology. I mean, and I come from a science world. We don't make things up as we go along. We learn, and then we improve, and we understand 20 years ago was different. And it seems this is being controlled by a non-scientific body with power, and I don't think it's helping anyone. And I think the business community's goals and the government's goals of making ourselves secure in data security this is not the proper resources to spend. I mean, like I said, Snowden walked out with a thumb drive. So the big picture is really being ignored here.
So your point is that there are lots of other real security vulnerabilities that maybe the FTC and companies should be focusing on.
Well, I think we need to start with standards first.
Okay.
I mean, it's fundamental.
So on that point, I want to invite our panel to come up here. We're going to get into that very issue about exactly what the legal standards are. I'll introduce them as they're coming up here. Geoff Manne, my colleague at the International Center for Law and Economics, is going to be moderating our discussion today. We have a great panel that includes my former colleague, Tom Sydnor. Tom and I worked together at the Progress and Freedom Foundation. Tom did a lot of the underlying work here on that story about LimeWire. Justin Brookman, please do make sure your name tags match where you're sitting. Justin Brookman at the Center for Democracy and Technology has been working in the privacy arena for many years, previously at the New York State Attorney General's office, and is going to be able to push back here. Oh, little lopsided. Do you want to come and sit over here by me? Be able to tell us, indeed, what's at stake here and why the FTC has an important role to play. This is Gerry Stegmeier, who's written some of the leading articles in here questioning the FTC's approach. And then finally, Reed Rubinstein from Cause of Action is representing LabMD in their lawsuit with the FTC. So having said that, I'll turn things over to Geoff as moderator and ask us to get started.
Thanks, Berin. So let me dive right in, and I want to start just by way of giving a little bit more background for those who may not be familiar with a quick summary of actually a small piece of one of Gerry's articles, which I think sets this up nicely. So according to a report published by Verizon in 2013, there were about 47,000 reported security incidents, 621 confirmed data breaches, affecting 44 million data records in 2012 across the globe. Most of these data breaches involved malicious activity by outsiders. In other words, most of the entities were victims of actually criminal activity. But of course, poor data security practices may contribute to data breaches. And while the entities that are the victims of these data breaches certainly have incentives to protect the information they collect, as Mike was describing, it's a serious problem if you don't, there aren't any federal laws, broad federal laws actually specifically requiring data security. Instead, the law has tended to focus on criminalizing unauthorized access. But into that vacuum, the FTC in particular has stepped, requiring reasonable data security for entities not covered by the few existing industry-specific federal regulations. The FTC bases its authority, as many of you may know, on broadly worded Section 5, which prohibits unfair or deceptive acts or practices in or affecting commerce. It doesn't mention data security in particular, and one of the things we'll talk about is actually where the source of that jurisdiction even comes from. Usually the FTC makes its case, the data security cases, as a deceptive practices claim. But occasionally, and as in Mike's case, the claim is brought as an unfair practice. All right, that's the 4-second version of the Federal Trade Commission's Section 5 authority here. And what I want to do is start by turning to the panel, and I'll start actually right here with Reed and Gerry, and ask if there's anything in particular that I missed in that basic background that you want to flesh out that sets the appropriate stage here in terms of understanding the legal environment we're operating in, and in particular what the difference is, if any, between the unfairness and deception approaches. Why, if there's a particular problem using unfairness in let's say in Mike's case, as opposed to deception, and if you have any thoughts to add about state laws or the sort of adjudication and litigation history here that helps just let us know where we are in the law here.
Everybody hear me okay? Thank you. So as everybody knows, and I think Mike alluded to, or the inside the beltway version, is that people generally understand that agencies get deference to their reasonable interpretations of the statutes that they're charged with enforcing. And the practical difficulty that many folks find with Section 5 of the FTC Act is it is incredibly broad, right? In other words, they get to regulate unfair and deceptive trade practices. And the challenge has been, well, how do we know what is an unfair and deceptive trade practice? Now, the premise of the article that Geoff was talking about that we wrote says, okay, let's take that at face value. The agency gets deference to reasonable interpretations of the law. But there's a constitutional doctrine known as the fair notice doctrine that essentially says, okay, they get deference, but if I couldn't possibly know what the law was at the time that I committed these alleged violations, then they can't enforce that law against me in that way. In other words, it violates my due process rights, and it's very consistent with what we call the rule of lenity, which is to say that criminal statutes are construed narrowly. And the gist of it essentially says, okay, the agency gets broad deference, but we should still be able to know reasonably what is required of us. And what the agency has said, and I don't want to get too far along, but what the agency essentially says, and I think Mike set this up nicely, look at the 30-plus consent decrees. And what I would submit to you is those consent decrees will tell you in a given case, on a go-forward basis, what the agency deems to be reasonable. But as somebody who's had to meet a payroll myself, what I need to know is what is not reasonable as a matter of law. Right? Aspirational versus required, floor versus ceiling. And that's really where the difficulty comes here. Because in many of these cases, people simply can't know.
So, Reed, feel free to answer however you like, but what I want to sort of direct that to you in particular, if you feel like addressing this. So, what information is there about what's reasonable? And how reliable is it? How useful is it for companies? And we'll talk more later. Don't get too far for now into this development of the common law point. But allude to that as you try to answer that. And again, feel free to fill in the background as well.
Right. Thanks. The short answer is there's not a lot. Cause of action is a nonprofit, nonpartisan government accountability organization. We use investigative tools and legal tools and communication tools to educate the public about government accountability and transparency. That's our institutional interest in this case. I think as Mike very eloquently laid out, the real problem here and the systemic harm and danger that needs to be addressed is a government that essentially is unaccountable and not transparent because the shoulders or the limits, however you want to characterize it, of its authority are not clear. This is an old problem. Those of us who've been toiling in this vineyard, for a long time have seen it from many agencies in many different contexts. The FTC delegation Section 5 is very broad. There are other similar delegations that have been made by Congress, and I think as we were talking earlier, Cass Sunstein, who used to run OMB, OIRA, very well respected scholar, was writing about these problems 15, 20, 25 years ago. And his point essentially was that in the absence of some sort of law, whether it's statutory law or regulatory law, is really not that salient. But there needs to be law. There needs to be standards. There are none in this case, and therefore you see the kind of horrific outcome that we had with respect to LabMD. And I don't want to talk too much about the specifics of that case, as you can well imagine, but I will say that we intend to defend very, very aggressively.
So, Geoff, I will just jump in here to answer that particular question and say the FTC's had very, very general standards about how you should secure your customers' data. They don't say much. They say they give you very broad guidance. In January of 2010, the very same month that the FTC sent that initial letter to LabMD, the FTC issued for the first time a guide, a very short guide, about peer-to-peer file sharing programs, saying, telling businesses, inadvertent file sharing is a problem, you should be aware of it, and you should take measures to deal with it. So if you want to call those standards, they don't give you very much guidance, but they came out only well after the fact. The FTC is essentially asserting in this case that a company like you should have foreseen well that inadvertent file sharing was a problem and taken certain measures to deal with it that no one at the time really knew were appropriate.
So we're gonna come back to this again, because I would just point out that as others, I think, in fact, as Mike even mentioned, right, I thought it was interesting, Mike mentioned that what the FTC said is, look, here's some consent decrees, go look at them, you'll know what the constraints are, what the issue is here. And I do want to talk about that some more, but since you brought it up, Berin, I think before we get to that, this is an appropriate time to talk a little bit more about the kind of factual background here and about the importance of P2P file sharing in understanding what's going on in this particular case. Obviously, all data breach and data security issues don't arise out of P2P file sharing. So to the extent that you can also, in answering these questions, talk a little bit more broadly so we can have a sense of the general environment here, that would be great. But I'll ask Tom first, if you can give us just a quick sort of summary, I suppose, of the report that you wrote, and more generally, what's going on with P2P, why it's a problem, and to the extent you can talk about it, how much did the government and the FTC, for that matter, know that it was a problem, and sort of maybe give some more background to Mike's comments about the FTC's role in working with P2P file sharing companies.
Thanks, Geoff. My name is Tom Sydnor. I need to clarify a couple things, maybe make a couple points clear when I start. I'm a consulting intellectual property fellow to the Association for Competitive Technology Act. I'm actually not here today in that particular capacity. I'm here in my personal capacity because I'm talking about work that I did when I was employed by the federal government at the United States Patent and Trademark, and there as an attorney advisor in their the copyright group of the Office of International Relations, and as a fellow at the think tank, the Progress and Freedom Foundation, where one of my colleagues was Berin Szoka. I've published 3 papers and testified twice in front of Congress about the issue of inadvertent file sharing and what causes it. I know a great deal about it. Berin has threatened has made it very clear that he will get a big crook and pull me off the stage if I tell you everything. So I want to summarize briefly why I think this issue of inadvertent file sharing, the problem that ultimately turns out to be at the or caused by LimeWire, the problem that ultimately turns out to be at the core of Mike's case, is actually quite relevant to this debate, because lurking behind this debate, and for my purposes talking here today, if you look at the Wyndham case, there are people and I'm sure in cases that may come, people argue about what the scope of the FTC's jurisdiction is in cases involving breaches of data security. For my purposes today, I want to put those questions aside and try to focus on a broader question, which is, let me assume for arguendo, for purposes of this panel, let me assume that the FTC does have some legitimate jurisdiction to act in the case of either deceptive or at a certain level fundamentally deficient data security practices. At some level those could be conceived to be unfair. We'll just assume for purposes of what I'm about to say. But even if that is so, there's a very important question lurking in the background, and that's that, right now we're running into all of us, both private in our professional lives and our personal lives, run into a problem that right now it is very, very difficult to protect your personal rights and your personal property when they're exposed to the internet. That's a big problem not only for us as individuals, it's also a big problem for the government. The government's fundamental task, its single most important and economically valuable contribution, is that it is there to protect the personal and the property rights of private citizens from unlawful use of force by third parties. So when you have a data security breach, maybe it is easier to go and assume that the company that has been victimized by somebody else's deliberate wrongdoing could be held strictly liable, and therefore you target the victim. But if that's the way we're proceeding, but if that's what's going on, then we have a really serious problem with the way our laws are being enforced. It's maybe not a question of what the law permits you to do, but maybe a question of what is the right way for the law to be enforced in this environment where the government is having trouble maintaining its monopoly on the use of force, and all of us are having difficulty protecting ourselves. So.
Tom, you were saying something about peer-to-peer file sharing?
Yeah, I was.
Well,
but this actually leads directly into it, because I think those concerns become most important if you're dealing with a situation in which the FTC is claiming that somebody has acted unfairly with respect to a data security problem that was not only caused by somebody else's deliberate wrongdoing, but potentially exacerbated by actions taken by the FTC. And that is exactly, I'm afraid, the reason I think Mike's case is very useful as a way to talk about these broader issues is, having studied this issue for years, that is exactly what I think we should be concerned are the underlying facts.
So
the FTC, so just to be clear about this, FTC was first asked to investigate the issue of inadvertent file sharing in 2004. It did. It investigated companies including LimeWire. It did a remarkably bad job of that initial investigation, and as a result decided to work with companies including LimeWire on correcting a problem that, had it examined more carefully, I think it would have discovered that they were actually causing, and quite deliberately. They were later made aware that this had happened as a result of research done by myself and data provided by a data security company called Diversa. As in two congressional hearings in 2007, 2008, and yet throughout that entire period, up to through 2010, the FTC continued to work with LimeWire on the problem of inadvertent
Tom, can you tell us
file
very quickly, rather than sort of the structural problem of the relationship with the FTC, what we need the background on is what the problem is with LimeWire, the technological problem.
Nothing unique to that program.
Yes, I'm sorry.
A very short primer on inadvertent file sharing comes down to this. In 2002, there was a computer science study published by a guy named Nathaniel Good and Aaron Kreckelberg, now Dr. Good, Mr. Kreckelberg, that identified two features in the file sharing program Kazaa that could cause users to share files inadvertently. Those two features, identified in 2002 by independent computer science researchers, are the only two that have ever been identified that were capable of causing this sort of catastrophic inadvertent sharing of, like, for example, a user's My Documents folder and all of its subfolders that have been identified since. So in Mike's case, it is clear that one of those two features that were not in the LimeWire file sharing program in 2002, but were later added to it after LimeWire had drafted a code of conduct promising never to incorporate them into its program. They subsequently were, and as a result, the locus of inadvertent file sharing shifted from the Kazaa program to LimeWire. The two features are and I can describe and you know, a brief description of them will do here. If you want to actually see pictures, if you look at my published studies, I've got they're detailed. I have detailed screenshots. One was what is in effect, you could call it a save or a share folder feature. It looks like what you're doing is you're picking a folder in which to save files that you download from the network. In other words, it looks a lot like the Save As feature in Microsoft Word. Problem is, when you select a folder to store downloaded files, that folder and all of its subfolders are shared. Not just the files you download, all the existing files. And so what people were doing is they were changing that to a location that was easy to find, like My Documents. And if you do that, all of your personal data, everything, goes up on a file sharing network controlled by identity thieves. The other one, which was just as bad in a slightly different way, could be called a share folder feature. That it was just a little subroutine that would run the first time you installed the program. You'd only see it once when you were a brand new user, and it would recommend folders that you might like to share. And one of those in both Kazaa and LimeWire was My Documents, precisely the folder that will cause absolutely catastrophic inadvertent sharing of files that nobody in their right mind would want to put on the Nutella file sharing network. And that is the short of the matter is, FTC was aware of that problem long before LabMD was. It had multiple chances to stop it, multiple chances to target the least cost avoider, LimeWire, and it didn't. And
so,
that,
Justin,
Can I just back up and maybe provide the FTC perspective here, or do you want to go in a different direction?
I actually would like you to do that very, very quickly, and then I have another question
Okay,
for you.
so I mean, look at it from the FTC's point of view. Their job is to protect consumers. Specifically, the attorney's jobs are to find impact cases they can bring to set rules of the road prospectively going forward to make corporate practices better for people. They have a complaint database, and then overwhelmingly, the number one complaints both FTC gets and that I got when I was in New York State was about identity theft, right? So they wanted to do something to stop identity theft. And the question is, well, who do they go after? Do they go after the hackers? Do they use civil authority to try to go after a hacker in Estonia? Or do they use their civil authority to go after corporations here in America who could then change their practices and then offer better security to prevent those? So they decided that it did not make sense for them to go after the hackers. They started bringing data security cases in 2004 against companies who just didn't have good practices to protect the data. And from a consumer protection point of view, those actions, which were arguably against the victims, so I think the victims in my point of view are the consumers, have been incredibly, incredibly effective, right? They've taken a statute which is intended to be very broad, to apply to a broad range of new activities, right? So you don't need to pass a new consumer protection statute every time some new practice goes on. They've taken that, applied it to a new area, and the result of that, companies are now greatly incentivized to invest in security practices from this and also from state data breach notification laws. And with regard to P2P, what they were doing was they were looking for an impact case. They wanted to make an example of someone. So going forward, people would see the news clippings and say, oh, well, maybe I should put controls in place to make sure my employees are not putting P2P software on systems that house sensitive information. That was their goal, and from a pure consumer protection standpoint, it absolutely makes sense to go about it in that way.
Point that Justin raised that is, I think, a good one, highly relevant. Obviously, the equities are different if you're dealing with a hacking that originates from, say, Estonia. Just to be clear, LimeWire was not based in Estonia. Its corporate headquarters were in New York. Okay. And so as a result, it was subject to the jurisdiction of U.S. law enforcement.
The interesting point here that Justin raises is, in a sense, the FTC is asking you to take the world as given, right? There is LimeWire out there. There is a particular type of harm that we, the FTC, purport to be concerned with, and that's the dissemination of this sensitive information from users. LimeWire may be the cause of that, but you, the company that is the possessor of this information, has a responsibility to keep it protected even from the depredations of the LimeWires. So assuming that's a fair characterization of what you said, Justin, or close to it, I guess I want to come back now to Gerry and say and ask, what is how appropriate, I suppose, is that? I see that, and we've discussed this before, as essentially imposing something that amounts to a strict liability standard. If the information gets out, we don't care how it gets out, basically. It's your problem, and you need to do something about it. Justin says that provides a lot of deterrence, and that may be the case. But what are the costs on the other side from this type of standard, I suppose?
Yeah, so two things. One, it's important to keep in mind that in a lot of these cases, there isn't necessarily a breach. There isn't necessarily evidence that the information is actually leaked or that any damage or harm has resulted, across these cases. So that's sort of table stakes, right, is an assumption. The second piece is essentially what we're saying is we're going to take one victim and we're going to hold them accountable, right? They parked their car in a bad neighborhood, and because they did that, or they wore an expensive suit in the wrong place, they were far more likely to get mugged, and that really raises serious equitable considerations, especially where they really have no way of necessarily knowing. So I don't know if I've got sort of that exactly right, but what happens is our articulated standard is reasonable. And we'll talk about that, I'm sure.
Right.
But it actually isn't a reasonableness standard. In other words, any breach is an unfair practice in many of these cases. I mean, we've seen vulnerabilities that existed for 16 minutes that were reported by a company voluntarily, serving as the basis for an investigation.
So one part of your counterpoint to Justin's seems to me to be, actually, this isn't the most efficient way of solving this problem. If you go at it in this method, once in a while you'll find one or two instances where you actually provide some protection. But the real problem here is the LimeWire type, the P2P type functionality. And if you aren't actually going to go after that, you're really not offering a sort of comprehensive protection. The other thing that you raise, and that I want to talk about as well, is or that is I inferred from what you said, goes to the question of injury here. The standard, I mean, it does say in Section 5 that there has to be some kind of an injury. And we can talk about what that is, but as we talk about that, what I really want to ask us to address in particular is, we keep talking about information that gets out. What is the type of information that we're talking about here? We heard about what the information was in Mike's case. Is there a certain type of information that is inherently problematic? I mean, and is the FTC addressing whether the information is problematic? And obviously that goes to the question of whether there's actually an injury.
Really quickly, the agency has said repeatedly that sensitive information should get some additional level of protection. And I think we'd all agree some kinds of information are more sensitive than others. Commonly, Social Security number is a really common example. As recently as 13 years ago, I used to have mine printed on all of my checks. Everyone who received my check got my Social Security number. And I use that because what is sensitive information is something that is a moving target and becomes very difficult. Candidly, I can't tell you what it is. I could tell you what it is in some statutes, but that's where this becomes a difficult enforcement problem, right? Because businesses out there are trying to figure out how much security do they need based on what they have, often don't know, am I in magic sensitive information land or not? And then the second component, and just a quick one on this, is not only is it sensitive or not, but where you are in terms of contextually. Many of the cases that are investigated involve investigations of information that is public. In other words, I could do a search through a leading search engine and in a tenth of a millisecond return the same information that was allegedly compromised. So it's really sort of problematic because we all think security is good, but how much do you have to have as a matter of law is the tough part.
One point on inadvertent in the file sharing context. There's no question in my mind that putting aside Mike's particular case and whether anything got out of it or whether it qualified as sensitive, in the context of file sharing, there's no doubt that there was indeed information that we generally consider to be sensitive that got onto the new file sharing network inadvertently, including mostly the most well-documented problem related to actually government documents, including documents that were not just classified, but classified secret. The plans for the Pentagon's, for example, this came out of the 2007 hearing, secret computer backbone complete with router addresses and passwords, shared by the IT specialist at a contractor with a top secret clearance. That caused the CEO of LimeWire to claim that he had thought inadvertent sharing wasn't that common and it was just unsophisticated users, but gosh, that really made you think that it was even sophisticated users.
So let me jump in here just on that point and to emphasize, everyone here is saying that the FTC had some role, and among the things, well, I certainly, hold on, let me finish. Among the many things the FTC really clearly should have done here was to go after LimeWire. And that's not just, and I'll say that, the FTC did do that back in 2011. After all this happened, the FTC finally went after FrostWire for having designed its software, in particular the mobile app, that basically was LimeWire for your phone, in such a way as to trick you into sharing all the files on your phone. The FTC brought that enforcement action. It was widely applauded for doing so. And I think in connection with this story, that's an example of the FTC finally admitting that they really had it wrong, that they should have brought that sort of case much earlier, and if they had done so,
but
they
they're
could
not
have gone
mutually
after
exclusive, and
well,
the FTC certainly wouldn't suggest that they shouldn't be bringing other cases as well. And I want Reed to address really quick, Tom.
But I'm sorry,
Tom, please. And I want Reed to address in particular, I suppose, whether you actually think that there is sufficient FTC authority here. Partly that depends on how they're using it, of course, but not entirely. And I don't think the fact that they went after LimeWire necessarily changes your feelings about the appropriateness of the FTC's exertion of authority here.
Not a bit. And I don't think it's at all fair to say that everybody here thinks the FTC has any role to play with respect to data security. That's an open question. If you'd let me finish. It's an open question. And it's certainly an issue that we are going to challenge in this litigation. It is an issue that has been challenged in the Wyndham litigation. It is an open question. And you can have discussions from a practical standpoint about who is best suited and who is best capable to regulate data security and data breaches and so forth. But this is still a country with a constitution, beginning, middle, and end. And that's where the analysis has to start. And because the agency in this case saw harm and decided to go off on a frolic and detour without following the procedures that are laid out either in its own authorizing statutes or in the Administrative Procedure Act, and decided that there was a problem that they were going to fix, whether they were right that there was a problem and whether they were the right people to fix it or not, you end up with some very profound problems. And the practical manifestation of those problems is what's happened to Mr. Daugherty and his company. So there are a couple of issues here, and we have to operate in multiple dimensions. There is the practical issue about how to regulate, but then there is the more fundamental constitutional question about who has that authority and how is it to be exercised. And that, from our standpoint, is really the big problem with Mr. Daugherty's case.
I just want to clarify, because I completely was misinterpreted there. The FTC should be bringing these data security enforcement actions, but instead that if there is a problem like designing software in a way to trick users to share information that in turn causes data breaches, that's where the FTC should be. Those cases, they're fundamentally different from the sort of case that's being cases
so,
the FTC's brought.
Berin, you're making a normative argument that's sort of where they should be going.
But I'm also
I want to get to that. So I want to get to the normative argument as well. But by way of getting to the legal argument, I want to ask you and Justin, do you think that indeed the FTC has the authority here to go after the data security cases in the way that it has? And do you think that there are sufficient limitations? I mean, Justin, are you satisfied with the way Section 5 is written, the way the FTC has interpreted it, and the nature of the FTC's enforcement? Are you satisfied that they're going about it in both a legal and appropriate fashion? And Berin, I don't know, maybe Justin, you can go first, and then Berin, if you would respond. I know you have pretty different views on this, but I would like to get at this issue of the basis of authority and the real scope of limitations, if any, that are written into Section 5.
Yeah. I am not, but focusing on Section 5 enforcement in general, I think by and large they're doing the right thing. It was intended to be a very broad statute to apply to a broad set of consumer harms, right? And it's not like, I dispute the idea they're going after someone who just happened to park their car in a bad neighborhood. They're going after someone who parked someone else's car in a bad neighborhood, right? And they're taking people who mishandled someone else's personal information. Consumer protection statutes are not about evil intent or any scienter whatsoever. All they need to do is find a practice that causes harm, that can't be avoided by consumers, and is not offset by reasonable benefits. Now, in this particular LabMD case, I mean, I do think the complaint should have been fleshed out a lot more. I mean, I have trouble assessing the merits of the case based on the relatively scant information within there. I do think the premise of what they're going for, that companies should put in place measures to make sure that computers that handle sensitive information should be locked down to some extent, is a good thing. That idea gets socialized is a very positive thing for consumers.
Berin?
So as a legal matter, I have a problem with is the idea that is going to build what it calls a common law in this area simply by bringing one enforcement action after another without ever having faced a court. I mean, it's worth remembering here that the FTC has been bringing these cases since 2004 and never ever litigated. What we call data security law is not law. It's not law in the way that antitrust law is law because courts have ruled on something. It is what we called in our Wyndham amicus brief, it is really nothing more than an infinite regress of unadjudicated assertions.
That was a good line.
Now, and I think I wrote that line, not you, Geoff, but
it was definitely a joint thing.
But I raise that point to say that at the end of the day, the right answer, my point's a process point, the right answer shouldn't be set solely by the FTC. If the courts actually played a meaningful role here, if the FTC were actually litigating more, and if the courts did not, and we'll see if this actually happens, if the courts don't simply defer in every case to the agency's interpretation, and if the courts require things like fair notice, you have standards develop on multiple levels. Everyone uses the word standards here to mean that the FTC has never provided specific guidance as to what would be a reasonable data security practice. But of course, that's a hard thing to define. It's a moving target. What I think are more important are the two higher level standards as a process matter. So think of them as meta standards of, number one, what exactly does unfairness mean? The FTC said in 1980, as Justin indicated in its unfairness policy statement, that an unfair practice is one that causes substantial injury without countervailing benefits to consumers that consumers themselves can't reasonably avoid. They were forced to make that limiting statement because the FTC had so run amok with its unfairness authority that the Democratic Congress in the 1970s almost defunded and shut down the agency. And then the higher level standards, even above that, is a set of basic constitutional due process principles. And that's where Gerry's concerns about fair notice come in. So I think if you had this law develop over time through adjudication, the FTC would be reined in. And if it turns out that the FTC can't appropriately pursue data security enforcement actions, that's a problem for Congress to resolve, not for the agency to simply make up. And just one final point. Okay. It's also worth pointing out there's another source of law here that never gets talked about, which is private contracts. So Visa and MasterCard and other private companies already require data security in their arrangements with vendors. So that means, for example, that if you are securing, if you have credit card numbers, you have to, per your contractual relationship with the credit card company, you have to secure them in a certain fashion. And one of the concerns that I have here is the FTC is really using consumer protection law to protect companies.
And
to
it has no history of that.
to displace the companies protecting themselves from harm. That's certainly true in the Wyndham case.
So I want to get to you, Gerry, but just quickly first, and you can respond to this as well, but this is sort of to just tie up what Justin and Berin have been talking about. So Berin, one sort of response to what you just said is the response that the FTC has made, and Justin, I want to put this to you as a question whether you agree with this. Remember, when they came knocking on Mike's door, they showed him, they said, look at these consent decrees, and suggested that they provided some guidance at least. Now, that's not the same thing as providing any kind of a standard by which the FTC has to be bound, but as far as I know, that is what the FTC points to as anything that provides some kind of a limitation on their ability to exert authority here. So the question to you, Berin, is does that save it at all? And the question to you, Justin, is that actually sufficient? I mean, can that be enough?
But first, I mean, I think you can make an argument that data security standards, really should just be strict liability, right? I mean, data breach notification laws are strict liability. You lose the data, you have a very expensive obligation to tell everyone about it. Doesn't matter, well, I had really good security in place, man. No, you have to tell everyone about it. That puts, I think, really strong incentives on companies not to lose the data in the first place. I don't think the FTC has interpreted their statute that way. I mean, as Gerry says, like they say over and over again, reasonable, reasonable, reasonable. So I'm sympathetic to companies that say, I don't know what reasonable is. Looking at this basket of consent decrees doesn't do it for me. I don't understand what the alternative is, though. I mean, I don't want the Federal Trade Commission saying, yeah, I use 512K bit encryption instead of like 128. I mean, that's just not reasonable. I don't want them to prescribe what that looks like. And Berin, said, well, it needs to be more general than that. I don't know what that looks like. I mean, I'm open to it. I mean, I think it would be nice in theory. Like Berin said, I mean, there are FTC policy statements on this issue, but I'm struggling to think of what more they could do. I mean, is there an obligation to litigate these cases? And even then, it's still very fact specific, right? I mean, it's still one set of facts, and just as their consent decrees are. So I'm open to an alternative that the FTC should do more to provide guidance. I'm struggling to understand what that could be.
A couple of quick rebuttal points for Justin. He says it's someone else's car. Answer no. I've been taking detailed notes about our meetings here and what people are wearing and what I've observed through our interactions during the meeting. If those notes get stolen out of my car, I'm leery about the FTC prosecuting me for failing to lock my car properly in the neighborhood because I learned things by virtue of our interactions, right? I'm not your lawyer. I'm not your doctor, I'm not your priest, I'm not your psychiatrist, and we don't have a contract with Visa that says I have to safeguard that stuff. But under existing Federal Trade Commission precedent, if you viewed it as the common law, some folks might say, I don't have grounds to complain when I get a subpoena. Now, how does that matter in the real world? Because responding to that investigation costs $500,000 regardless of outcome. In other words, just the act of talking to them and answering their questions costs $500,000 on average. So it's not someone else's car. It's probably more apt what's in my car. Second piece, Justin says strict liability. Yeah, Justin says, well, if I didn't hide my notes in the trunk, then that's the rebuttal point. He says strict liability for breach notification statutes. Well, that's not actually the law. That's the law in many of the states, right? If you have a breach, then you have to provide notification. But in a number of the better states, you do a harms-based analysis, so it has two limiting factors on that, right? One is, was the information sensitive, right? Does it rise to the level where the mere letting it get out is problematic? And then second, a risk assessment. What is the likely harm, for example, of you having employed software where if someone did something, a file could have been seen?
That's still strict
Right.
liability.
So it's still a harms-based approach with respect to whether you have to do a notification. which means there's the application of judgment. And when Geoff asked, what's the downside of strict liability? The answer is when I fear strict liability, I overinvest, and I have no way to know. I mean, I have to tell you, speaking individually, I've had clients say, well, what should I do for security? Because they have no idea what the requirements are, and they say, well, that sounds to me a lot like I'm damned if I do, damned if I don't. And that's not where we want to be, and I know that's not what Justin's suggesting.
There are some very practical things the agency could do. It could go to Congress and get statutory authority if it wanted to apply a strict liability standard. It hasn't been able to do that. It could do a rulemaking, which is what the statute contemplates. That's hard. The agencies don't like hard. It's much easier to sort of get consent agreements and then implement them. But you know what? It's been done by other agencies in other contexts. Those of us who are old enough and who lived through the 1990s remember the all-appropriate inquiry standard that EPA developed. Because in the Superfund bill, there's a requirement, there's basically a strict liability scheme that Congress passed, but there's a carve-out from liability for people who use all-appropriate inquiry. But there's no definition for that term. And it created tremendous angst among lenders and landowners and state regulators and whatnot for 20 years almost. But there was a process, and the agency kicked it off, and it developed a flexible set of guidelines in consultation with industry association, and you ended up with standards that are applied across all 50 states in all sorts of different kinds of particular contexts that are flexible, that are moving, but at the same time have fixed reference points so that companies and individuals know going in what the rules are. And they are therefore assured a level and fair consideration from the agency. So the notion that the only way the FTC, assuming arguendo, that that's where we as a society have decided the federal government authority to regulate data breach belongs, all right? We'll leave that question aside. There are plenty of things they could do to make it clear and transparent and accountable, which it is not now.
But tease that out for a second, right? You're saying the two things they could do are a statute, which still has the same exact problems, right? You can pass a statute, and the statute can either say, you know, you security, or the statute can be like the tax code and have like, you know, hyper-prescriptive things that need to be changed every 6 months. If you really trust Congress to do that, good luck to you. And then you say, you know, use MAGMOS rulemaking, which is the FTC's rulemaking authority, which takes like 12 years. They're a neutered organization, neutered in the 70s, and I understand for good reason. But still, it's just not practical that you're going to put in place a 12-year rulemaking process for security standards that you don't even have any idea what they'll look like in 12 years. It just seems like fantastical to think that's really the solution.
Okay, so first of all, Geoff had to apologize. He had a prior commitment. I'm taking over as moderator, so let me exercise my newly restored moderator's prerogative just to a few things here. So I think the FTC, they use the word reasonable. Unfairness policy statement, if it contemplates anything, it contemplates that sort of standard. But in fact, as Gerry's saying, the actual approach they've taken is very clearly a strict liability standard. Now, you might think that that's a good thing. We can have a policy discussion about whether that's the best way to approach this, but it's not legal. At the end of the day, the FTC's basis for jurisdiction they're asserting here is the unfairness policy statement, which specifically contemplates a balancing of interests. It requires the agency to weigh injury and the likelihood of injury against countervailing benefits, and countervailing benefits writ large. So the FTC will sometimes say things like, there are no countervailing benefits to having bad data security, therefore we're done, any breach, there's a harm, and so we're done. That's clearly not what Congress had in mind. Congress clearly had in mind weighing the overall costs of regulation. In other words, unfairness is about cost-benefit analysis. So I think to get to, this is a way of bridging to your question about what would the law actually look like. So what the law could look like is a way of giving more clear guidance as to how to make those standards, those decisions. At what cost point does something become unreasonable? So Mike, for example, has a small company. Does Mike have to spend 50% of his budget or 10% of his budget on data security? Does he have to buy filtering and monitoring software for his network that isn't available for small companies back in 2008 in the way that very large companies do? These are the sorts of questions that are very statute how do you build flexible law? And let me just give you, so this is your question. Back in 2003, 2004, when the FTC was first asked to look at this problem, they could have, on the one hand, gone after LimeWire to deal with the problem of inadvertent file sharing at the source. On the other hand, they could have said, you know, to work out in a multi gotten into the business of enforcing through unfairness jurisdiction in the way that they have been, but instead could have enforced against whether a company actually lives up to industry best practices. The White House has been very clear, the Commerce Department, I think, rightly recognized that that sort of bottom-up multi-stakeholder governance is technology. It could have been applied to data security instead of taking of beating up on companies for not having what the FTC decides after the fact would have been reasonable.
I'm just a Virginia lawyer, grew up in the suburbs, and I don't get over here to the Capitol and sort of inside the Beltway too much. So what a statute should look like or not look like, I think is a multi-decade endeavor, and we've seen it happen for 10 years in Washington in privacy and data security, right? In other words, before they couldn't agree on the budget, they haven't been able to get privacy and data security legislation through. But I want to be clear about what I am not saying here. I am not suggesting that reasonableness standard can't work. What I'm suggesting is that the agency can't tell you when you ask them, what do I need to do, what does the law require, in any meaningful way. And I would submit to you that governing is hard, but that doesn't mean that we don't pursue doing it the way that the Constitution requires. Now, the C word, if you will, very large, powerful thing, but we have this notion, right, within the fair notice doctrine that says we're going to give the agency the broad latitude it needs to interpret the statute that Congress has entrusted it to enforce. They're going to get reasonable interpretations. The court will uphold those. But the constitutional check that we have here is unless LabMD at the time of its conduct couldn't possibly have known by looking to any authoritative guidance from the agency what the law required. And I think authoritative is important. And it's kind of a legal point here, right? But the cases say the guidance from the agency needs to be authoritative. And in the other administrative law context, in a case called Meade, we basically have come down to a lot of things that the agencies say are not authoritative, right? If a staff lawyer tweets out, this is what the law says, guess what? You're not going to be held accountable for what that staff lawyer said. But we realize in this context, and that's what a lot of the complaint is about, is people feel like that is what's happening, right? So we have boundaries here, but at the end of the day, there's a role for principle-based standards, but those principle-based standards often are telling us what one should do, and the trouble is we need to know what we must do.
So I want to give Justin a final word before we turn to the audience for questions, but just remind us that whatever guidance the FTC has issued here about peer-to-peer file sharing was only issued in 2010, 3 years, at least 2 years after this happened in the LabMD case. And just again, by coincidence, the very same month the FTC started putting pressure on LabMD. So Justin, final comments before we turn to questions?
Yeah, I still think it's really, I still haven't heard articulated, what that guidance would look like. I mean, the examples you use, whether he should spend 10% or 50% on his budget on security, I mean, you want the FTC to pick a number? I think that's insane. I mean, I don't think you're saying that, but I also don't know what you're saying, so maybe you should be able to respond. I mean, whether they pick filtering software or not, I don't want the FTC making that determination. I mean, it just seems...
But the FTC is making that determination. So at the bottom line here is we have sort of the worst of all possible worlds, right? We all agree that it would be bad to list everything that you should have to do because it's difficult to freeze that in place at one particular time. The problem is in order to try to build a flexible law, the approach the FTC has taken has been the worst, most ad hoc way to go about that, of simply saying, oh, no, that's not good. In that particular point, that was not a reasonable practice with no real justification. So in other words, it's a little bit like playing Mother May I, except you're not actually asking. It's more like Mother comes back and smacks you all of a sudden out of the blue for something you did 3 weeks ago without actually really explaining why, and then says, you see, kids, don't do that thing that just happened 3 weeks ago. You should have known better.
Because it's designed to have perspective for us. I mean, that's the intent, to change behavior going forward. Unfairness was designed to be incredibly broad, right?
Well,
that was the point.
And if that's the point, if that's what we're trying to do here, I think the number one thing the FTC needs to do is to explain the cases it's bringing better. So at a minimum, even if the FTC doesn't litigate more, even if the courts don't get involved, I think you're absolutely right, Justin, that the complaints the FTC brings today are not adequate for a person of reasonable intelligence or even a fairly sophisticated lawyer to understand what exactly is the practice that was unreasonable here. What should LabMD specifically have done differently? That's a systemic problem that the agency could fix today.
I actually think most of their complaints are quite good. I think the one in LabMD is very difficult to parse through.
Okay, well, fine.
So there's one quickie. The complaints are very good about telling you what someone must do on a go-forward basis under the order. And we would all agree that that is an example of reasonable behavior. But keep in mind that the law is going to punish you for acting unreasonably. So when you define the box as everything in the box is reasonable, the problem here is that everything outside the box is unreasonable, and we don't know where the boundaries of the box are. And we don't have mechanisms through which we're being told. And the agency is very specific about saying the complaints apply to a specific case, to a specific individual and specific conduct. And frankly, much of the conduct is never, it doesn't occur in the complaint. You couldn't read it, right? Where we've done 20 of these cases, there are lots of things that I could tell you, any of them that I think are probably within the common law, but you couldn't discern them unless you actually tried to negotiate with the agency. For example, the fact that you really doesn't matter. Standard, in my experience, doesn't necessarily militate with whether you're big or you're large. It's you're secure or you're not.
So, we're going to turn things over to the audience to ask questions. Please wait for the mic. We have a live stream audience here. So, Carl, in the back, you want to start?
Thank you, Berin. Carl Szabo with NetChoice. One of the things that I think Gerry kind of hit on, which came a bit shock to me, we have 47 state data breach laws right now. We don't have a federal data breach law, but it sounds like even if I were an attorney and I had a client who had a data breach and I go through my 47 state survey and tell them, send out this notification in Massachusetts, this in California, the specter of the FTC is still in the background that it might be able to bring yet another action against my client. So how should attorneys begin advising their clients when there is a data breach they discover?
Hand out cards afterward if someone would like an appointment with us. I'm not sure I understand the question exactly, Carl, except to say that I think Mike earlier pointed out, the people inside the Beltway will say that's just the way it is just the way it is. Take HIPAA, for example, right? You have state AG enforcement, you have Office of Civil Rights enforcement from HHS, you have the specter of private class action litigation. For lawyers, it's an incredible opportunity on either side as plaintiff or defense counsel. So, defending, multi-front prosecutorial risk is something that, many lawyers are comfortable with and are well positioned to help companies do that. But I think what you pointed out is it is a very legitimate real risk, and it happens, right? The act of notifying isn't going to make something go away, and in fact, often it makes it worse. So if you're at the margin trying to decide notification or not, there are plenty of cases where the act of notification actually made the situation worse for those enterprises. Or put a different way, the unintended consequences, you try to do the right thing and you pay a much higher price.
For worse, we have a federal system with 50 sovereign states. That's what you're going to get.
I would just add to that, the basic advice that lawyers give their clients in these cases seems to be settle. Ultimately, that's what happens. That's why this case is so extraordinary that Mike actually decided not to settle. We have a question here. You want to, Dave Carney?
David Carney. I have a question about procedure at the FTC. I understand you have an administrative proceeding now. Is that decided by staff, by an administrative law judge, or the commission? Do you then have an administrative appeal? And then for judicial review, does that lie in a complaint to the district court or a petition for review to the Court of Appeals?
Right now, we have a matter before an administrative law judge. It would then go to the commission, and from there it would go to the district court.
We'll point out here that the FTC has the discretion to decide whether to, after having put a company through the ringer through that compulsory investigative demand process, they can then decide should they go to federal court or should they bring them through their administrative adjudication or Part 3 process. It seems to me that the FTC's ability to do that is yet another reason why companies settle, because after having spent, as Gerry was saying, at least $500,000 on dealing with that discovery process, or in the case of Wyndham Hotels, $5 million dealing with discovery, then if the FTC says, so you want to settle now? If you don't settle, we could just put you through our internal process where we'll probably win once at our administrative law judge and then once again at the commission. And only after all of that, after 2 more public defeats, which we will be sure to rub in your face, then maybe you'll get your say in federal court. That's a problem, and that's one of the #1 things I think needs to be changed about the agency that would help to build law in this area. And for what it's worth, I will just note that the FTC at least had the decency to bring the Wyndham case directly in federal court. For whatever reason, they decided not to do that in the LabMD case. They could have gotten us to a judicial adjudication earlier if they decided to do that. And I certainly hope it wasn't vindictive, but that's the sort of message that companies will seem to take from that.
React quickly. So earlier, Tom made a variety of points about disclaiming relationships to past work, prior work, current clients. And I observed that our firm had the good fortune to represent Wyndham at the Federal Trade Commission. And despite everything that I think we're hearing today about the agency and behavior, at the end of the day, they're good people committed to doing good things. And I wouldn't overgeneralize from a particular instance what the great work that the agency has done or how improvements it has been made. In other words, let's not let Justin be the lone voice about there's a lot of benefit to consumers about things the agency has been doing, an enormous benefit. But what is often lacking in those discussions is a cost-benefit analysis, right? So Justin and I agree on all kinds of things, and yet as we sit up here, we have a vast disagreement on whether or not what I learn about him in the course of this meeting, I have an obligation to secure it. And we're professionals and specialists in this area. The public in the United States, we haven't settled our views on what privacy is, on what security standards exist, and the agency is learning as it goes. I mean, I've seen in 10 years the technical competence of the agency increase dramatically. But that isn't without cost, right? I mean, at one point we had over that were under investigation because they were in a particular industry and the agency was learning. So I think, you know, one of the things that sort of comes out of this, and I think the best, and just a quick example, when we think about privacy and data security from a public policy perspective, a lot of people would say it is important. But what else is important, right? We're hearing that constitutional values and due process are important. We're hearing that things could be better, but I'd use this example from healthcare. With Obamacare and a variety of principles that we're trying to implement, there's been a lot of criticism of privacy and data security efforts, right? That if you create these exchanges, you can't secure the information adequately. And it's forcing a very important public policy conversation, which is, okay, privacy and data security has a cost, right? Would we all want to drive our car if in order for that to be secure, gas is $3 more per gallon? And the net effect of a lot of what the FTC is doing in breach notification laws is the expenditure of billions and billions of dollars, candidly probably to secure information in many instances that I used to put on my check 10 years ago.
Briefly, there is, I want to support what you said. The people at the FTC and at most federal agencies, all, at least in my experience, are fine people. That is entirely besides the point. The problem here, and it's, you know, what ought to trouble everybody in this room is how profoundly anti-democratic it is for the agencies, federal agencies, whether it's the FTC, the EPA, or any of the other agencies, to be doing what it's acting as it is. Because there is no transparency, there is no accountability, there is no clarity. And that really is the fundamental issue. Again, they are good people, they're very bright people, they're trying to do, in their view, the right thing, and they're to be commended for that. But it's frankly irrelevant.
I agree. I think we have, as a society, made some.
You don't think the FTC are good people?
I want to disagree with Gerry. I think we have made some determinations as a society about what privacy means. We have decided, I think, that there are certain sensitive categories that are important and do merit protection, which is why we have notification laws.
Which ones are they, just so we can make notes?
And so that's right. I mean, there are areas where we haven't figured it out, right? So I would say, you know, what I was wearing, what suit I was wearing at this meeting in a public place, I would say no. I think there are some gray areas like email addresses, right? Do we have a privacy interest in email addresses? If they get leaked, we might get more spam, but they're public anyway. And that's an open question. But sensitive data, like, you know, financial card data and social security numbers, that determination's been made. There is a privacy interest there. I think that is that's unquestionable. Now we can talk about the cost-benefit analysis,
but Justin, for everybody else that isn't a privacy lawyer in the room, we have detailed federal statutes with comprehensive federal rulemaking in each of the examples of sensitive information that you just identified.
And I would like the Federal Trade Commission to have rulemaking authority and penalty authority. That would be great. Real rulemaking authority.
I might add, coming from a medical background, what I find really disturbing and interesting is that I think technology has moved so fast. The thing that's underlying all of this is the speed of light and change here. And that is making everyone, good intentions or not, difficult to get their arms around this. And if the agency would just acknowledge that, putting my head on a spike is not going to affect the overall goal here that we're all interested in doing. And especially when we ignore the Constitution and due process. These are all important things. And I'm not one arguing that we shouldn't have government agencies. I'm arguing that this is a democracy with intentionally separated branches of government just for centralization of power shouldn't be happening because these are the things that go down. And the effectiveness of the goal is going to be compromised if the conduct continues as it is.
Up here, but let me just ask you, Mike, because I meant to ask this question earlier. So you've got your book here. It's a provocative title, The Devil Inside the Beltway. There are scary eyes that stare out at you from behind the American flag. Is the devil the FTC, or is it a mentality?
No. And actually, who the devil is inside the book. But the devil is a mentality. It's really not about the FTC. And really, this book isn't really about the FTC per se. This is a book about the ends up more power without knowledge, and it's a story about what happened, and quite frankly, there's a blue eye and a red eye. It's not even partisan. So no, it's not.
Read the book. If you want to find out, read the book.
Okay, well, I'm going to give you each a chance to wrap up. Justin, you want to start us off here? Just any parting thoughts you'd like to leave us with?
I guess my parting thought is really mean. That making an example of you, I'm sorry, right? I mean, there is a benefit to consumer protection. Now people know, oh, maybe I shouldn't have file sharing software on this computer. That's important, right? It's really bad. And you can question about whether you were morally culpable, whether you should have thought about it and do the cost-benefit analysis, but there's a clear benefit. And you know, looking at the comparative justice perspective, like, well, other people got away with worse, right? Snowden walked out with the thumb drive. I mean, the FTC can't do anything about that. There's lots of things we should be doing. We should be solving global warming. We should be fixing the debt. We should be fixing healthcare costs. FTC has a limited ambit, and security is incredibly important, and they are bringing the cases they think are important to change behavior going forward, and the statute was designed specifically for that.
This is I think the reason that the LabMD case, it strikes me as important, a couple of reasons. Number one, this is a problem the FTC could have solved. Could have solved it years before Mike's company had a problem by going towards the least cost of by targeting the least cost of avoider, LimeWire. Number two, I mean, I think the point that was made earlier is a very important one. We ought to be very concerned if we're talking about about not drawing distinctions between large and small businesses. We're talking about data security standards. That is also a point that's particularly important in the context of inadvertent file sharing, because as MIT's network administrator made a point he made in the 2003 inadvertent file sharing hearings in the House, these programs are designed to go where they're not wanted. They'd be very easy to exclude if they communicated over a designated port, but they don't, because they are designed to make it difficult and expensive for people to keep them off their networks. That's pretty important. That means you need to draw a distinction between large and small businesses. Last but not least, I think Reed made a very good point when he mentioned that the bringing some of these issues up. My basic point is just, look, doesn't an agency need to think that in enforcing rules about unfairness, whether it might have done some things that made it more difficult for the person it's accusing of being unfair to avoid that harm? I think it should. And his point, the point he made earlier, was that agencies do have a duty of reasoned decision making. That's true in the context of adjudication or rulemaking, and it may be interesting to see whether that issue comes up. Thank you.
So I think this has been a really instructive conversation, and I really feel for Mike, having had to meet a payroll myself in the past, and coming from a long line of entrepreneurs who were good at cash flow but never good at profit. I think the most important thing that I'd like sort of the audience sort of take away here is that it's highly unlikely as a matter of law that the Federal Trade Commission's authority under Section 5 is going to be construed narrowly. And what do I mean narrowly? Candidly, I mean in any way different than what they think it should be construed. If you're a betting person, the odds are against you on that bet. But conversely, there's a bigger debate here, which is the doctrine that we wrote our paper on. It's called the fair notice doctrine. It's not the notice doctrine. It's the fair notice doctrine, which means that there are equitable considerations that need to be taken into account. And essentially what we're talking about is a simple gut check. Could the people have known at the time that in a specific case, conduct was required? Not should have been required, must have been required. And the conflation of should versus must is really what's driving all of this, right? Because we're not talking about a rulemaking proceeding, right? The agency has COPPA, they have Gramm-Leach-Bliley, they have the Fair Credit Reporting Act. We have all of these other examples where we have statutes and we have rulemaking. We have things that don't work very well. There are all kinds of problems with those things. But let me tell you what we don't have with those mechanisms, generally speaking. We don't have the notice problem that we have here, right? We haven't agreed as a society on privacy. We don't have a consensus there. I'd respectfully disagree. I think we have a consensus that privacy is important. We don't have a consensus about what it is and when it matters. So how do we work through that? Well, when we have the rulemaking process, one of the upsides of that is that we hash out all of those disagreements and we get to a rule, and hopefully more people know how to behave, and they go, it is a bad rule, but it is a clear one, which is the first thing I learned about administrative law, right? Plenty of bad rules out there, but if they're clear, I know what's expected of me. And that's really what we're trying, from a perspective of our piece that we're writing to say. And I don't have a position on, broader FTC rulemaking authority, except to say that in the rules that we have, this fair notice problem has been addressed.
First of all, thanks for doing this panel. As I said, Cause of Action is a government accountability organization. We fight for government transparency and accountability. We are pleased to represent Mr. Daugherty and his company in this matter. We fully expect that when all is said and done, that the FTC will do the right thing.
Well, I'll wrap up, first of all, by thanking Cause of Action for co-sponsoring the event today, thanking Mike for coming, and just for my part, I'll say that It's worth thinking back to where the unfairness policy statement came from. So 1980, the chairman of the agency essentially made a deal with Congress that in exchange for not shutting down the agency forever, the FTC would cabin its authority by issuing those basic principles we talked about earlier, that a practice is only unfair if there's an injury involved that is not outweighed by countervailing benefit, and it's an injury that consumers themselves can't reasonably avoid. If you want to understand where that comes from, you have to understand what happened in the 1970s, which very briefly was that the FTC interpreted a case that the Supreme Court issued in the 1960s, saying that they were to operate as a court of equity, that they were to go out and to do justice, essentially. They're not legally binding. This was just something that the court included in an opinion. The agency ran amok with that language, and it brought them to ruin. It brought them to, first of all, having the normal rulemaking authority that most agencies have taken away from them, and having instead imposed certain procedural safeguards to ensure that if the agency actually issued rules, it did so on the basis of real cost-benefit analysis and showing that there was actually a problem. But the FTC basically is now doing, again, what it was doing in the 1970s in an informal way. Instead of actually issuing formal rules, it's just building much the same sort of result through an informal process of what it calls common law adjudication that really is just the FTC asserting in a particular case that a practice was unfair. So I will invite you all to come back on September 26th, which is the 99th anniversary of the Federal Trade Commission Act. We're having another event here to talk about where the FTC is going as it enters its 100th year and how the FTC's approach should change. And I'll just say for my part that I think it can and it should. I think it was probably a good thing that the FTC was reined in the 1980, but that ultimately if the agency is going to achieve what it's supposed to be doing, protecting consumers, its approach has to fundamentally change. It has to become consistent with the rule of law, with basic ideas like the fair notice doctrine, and it has to start rethinking its approach to things like data security and asking whether taking this sort of approach of putting heads on the spike, or as one of the EPA administrators put it, crucifixes on the road, is really the right way to protect consumers. There are other ways to go about doing consumer protection that I think the agency would do well for. So having said all that, thank you again for coming. Mike's book comes out on the 24th. I hope you'll see us here on the 26th. And please give a round of applause to our panelists, and thank you to LabMD.
And people online.
Indeed. Thanks for those watching.